May it please the Court, I'm Joshua Gordon. I represent Jonathan Lutz in this parenting case. Crystal doesn't really like the decision on the merits, but the Court here did the right thing. They both agreed on joint decision-making. Crystal wanted to share residential responsibility, even though she moved away to Massachusetts 2 hours away. This was a disintegrating couple with little history together, incompatible backgrounds, and lots of mutual suspicion. They had an unplanned pregnancy and no marriage in their future. Crystal was perhaps unready for child rearing, not a natural mothering type, and an unstable job situation. John is an obviously caring, capable father with a promising career surrounded by a very strong and very supportive family structure. You can't split the baby, and the Court picked the unfortunate best situation. Crystal's complaining about the presence of this Massachusetts preliminary finding of neglect. And her argument is that this bit of information skewed the entire case, eclipsing even 2 days of trial on the merits. But the GAL virtually ignored the Massachusetts finding. She knew it was preliminary. She knew it was based on one social worker interview with Crystal. She knew that John hadn't been interviewed. The GAL knew that Crystal felt that the finding wasn't accurate. She knew that Crystal had not yet been afforded her due process in Massachusetts. She knew that the Massachusetts DSS had closed the case, which is what the record says, closed the case after the temporary parenting order here. The Massachusetts finding rated just 40 words in the GAL's report, which is 8 single-spaced pages. Attorney Wolfson had a thorough cross-examination of the GAL at trial, and all this was unmistakably clear.
Is the underlying neglect that she left the child with her mother?
I don't know what the underlying neglect is. I've never seen the DSS report, and as far as I know, it's not in the court record.
Does the GAL say what the underlying neglect or what the allegations were?
I think it was a series of statements that taken together are troubling. I don't want the baby, or I'm hoping I'm not misquoting. She was scoping around for someone perhaps to adopt it. She had made some statements that could be seen as just an inexperienced mother, but also could be seen as a little bit troubling. And I think it was the basis of those statements, but I've never seen the DSS report.
How does the statute work here? Is it fair to say that this child, under the statute, had no home state?
No, I think that's completely untrue. First, the statute goes on residency, and it's the residency of the child, not the residency of the parent. And there's very little dispute here on the facts. Before Crystal moved to Manchester in February of 2007, she was working in Massachusetts full-time Monday through Friday, and she was living in Massachusetts for 5 days a week. She testified that during each week she left the baby in New Hampshire at John's mother's house. At most, she saw the baby on the weekends, and when Crystal visited the baby, she came to New Hampshire to do the visit.
Let me stop here, sir. I'll tell you my confusion. Maybe you can clarify it. I thought in the briefs there was almost a sense of agreement that the child had been a resident here for either 5 or 5.5 months before the petition was filed.
Correct.
And as I understand it, the statute says you have to be a resident of some state for at least 6 months, and if you have not been, then you don't have a home state, but then it goes on to discern how we'll get there. So help me on the 5 and 5.5 months.
Okay, we've got the 5.5 months are conceded, but the 5.5 months are from February 23rd, I think, 2007, to August 6th when the petition was filed. So that 5.5 months is conceded. So what we're talking about is December 06, from birth to February 2007, and that's the important period of time in which Crystal testified that Crystal was working in Massachusetts 5 days a week, had left the baby at John's mother's house for a week at a time, and some weeks went by where she didn't visit at all. So the baby resided at least 5 days a week in New Hampshire for the period between birth and February 2007.
So the 5.5 months is merely what the mother concedes. It's not what you are suggesting is the time limit. The mother concedes it was 5 or 5.5 months.
Correct.
You're saying that's a good beginning point, but we have to look at what happened on the ground.
That's right, and I really think that Crystal has conceded the 3 or 3 months prior to the period, the 5.5 months. She's already straight out conceded because her testimony.
Is it sufficient that it's in the best interest of the child to exercise jurisdiction in New Hampshire under the
statute? Well, I think that's sufficient here because the child obviously resided here. John Lutz's mother who was the caretaker of the child, so all the evidence is here.
It seems to me that the statute allows that.
The statute allows
the reviewing court to consider the best interests of the child in assuming jurisdiction.
I think that's true, but I think there's no doubt here that there was 6 months of consecutive time. So the wiggle room that's built into the statute doesn't really, we don't really need that here. We've got the straight out consecutive 8 or so months.
Wouldn't it have helped us at this stage if the trial court had made a specific finding concerning jurisdiction and the facts upon which it was based?
I think the court took it as so obvious, and I really don't think the facts were in dispute. When the court, when Attorney Wolfson started talking about it, the court said that's not in dispute, or words to that effect. Yet, during the course of the 2-day trial, there was a lot of evidence taken on the issue of where the baby lived when. So, I don't think that ruling was operated all that significantly.
Do we have a sufficient record here from which we can determine the jurisdictional issue, assuming it's been properly preserved?
Yes, absolutely.
What does the record show? The child spent one night with her grandfather a few days after she was born, and then my impression is, maybe it's incorrect, that the child came to New Hampshire, lived in Manchester, and would go back maybe for the day, perhaps for an overnight, to visit either the hospital or a doctor. Is that what the record shows?
Yes, with a slight modification. I think she lived in the baby lived in Hollis with their grandparents for that period before February. It wasn't until February or March that they moved to Manchester. So it's the disputed period, if there is any, is from December birth to February, and Crystal's own testimony is that the baby lived in Hollis. Crystal visited from time to time. The baby resided in Hollis. I don't think there's really much to the jurisdictional issue in this case. I want to talk a little bit about this DSS report, if I may. As I started saying before, the GAL didn't give this issue any weight at all, and the court didn't give it any weight at all either. It's only mentioned by the court in passing, and then only in the context of why Crystal didn't like John's mother. It's a safe bet that the court understood the differences between Massachusetts and New Hampshire. Neglect law, they are very different, but this is Master Love, who's been on the bench for 25 years. The court understood that it was a preliminary finding, that it was made only for the purposes of providing state services, which is what the Massachusetts statute says, and it's not probative because the standard of proof is so low. In Massachusetts, this initial preliminary finding, you only have to find reasonable cause to find neglect, and that is a very unprobative standard if we're going to use it for any other reason. And it's not like this was a jury trial. The Marital Master can discern irrelevant evidence. So the Master Love did exactly what she was supposed to do. She ignored it. And there's no prejudice by the Massachusetts finding, and Crystal already received the relief she's seeking. If she's making a constitutional attack on the Massachusetts statute, this isn't the right forum, and Massachusetts courts have already upheld it. But even if this were a meaningful issue, it wasn't preserved. The Massachusetts finding, the DSS finding, as far as I can tell, was not entered in the court below. It's not mentioned in the docket sheet in the court below. It's not attached to any pleading in the lower court record. It's not on the exhibit list, although it's possible my paralegal might have overlooked it. I don't think it's in the court file at all. It's not in the appendix to Crystal's brief. It's not before this court. You can't review it under Rule 13. In plain error, you have to, for plain error, to get around preservation, you have to allege some error and some prejudice, and there's just no prejudice. The short words, 45 or 50 words in the court order mentioning the DSS report is not for its probative value. It's for Crystal's feelings toward her grandparents.
Is that even an error?
It's no error. There is no error here. So based on all this, I want to ask that you summarily affirm the ruling below, and I also suggest a technical correction, I think, to everybody's brief. I think the DSS has been changed now to the DCF. Thank you very much.
Thank you very much. Case submitted?